The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon. Do we have lawyers here for both cases? Yeah.
Yes. Yes, we do.
Sarah, are we going to? Don't we usually ask the lawyers who are not arguing this case to?
Yes, I apologize. Let me get the video off. I apologize for that. Thank you.
I'm still learning the protocols. 2.5
sorry.
years in, or whatever it is. No, I meant me. I'm sorry. Good afternoon. We are very happy to have you here today, although we are sorry it's not in person. We will begin with our first case, United States versus Villa, and Ms. Hester, we'll hear from you.
Thank you, Your Honor. May it please the court. For a year before arresting him, police had been investigating Francisco Villa on suspicion of drug offenses without finding sufficient evidence of probable cause. As the district court recognized, the police were tired of waiting and resorted to a pretextual traffic stop, which culminated in a warrantless search of Mr. Villa's home and a subsequent arrest for possessing marijuana, drug paraphernalia, and guns. The district court concluded that Villa's consent to the search was involuntary and suppressed its fruits, which led to dismissal of the original alien with a firearm charge. But after losing the suppression issue, the government charged Villa with aggravated illegal reentry, which presents the court with several constitutional issues. I'll address why Villa's fingerprints and the records found with them should be suppressed as a fruit of the unlawful search, and then I'll address the vindictive prosecution issue. The district court relied on a legally erroneous interpretation of this court's decision in Oscar Torres when it denied Villa's motion to suppress. The court ruled that the exclusionary rule only applies to the fingerprints if officers arrested Villa for the investigative purpose of obtaining his fingerprints and the fingerprints were not obtained during a routine booking process. That analysis, yes.
Well, Ms. Hester, I'm sorry to interrupt, but I have sort of a threshold question about the suppression and exclusionary rule analysis here. I'm having trouble with the very first step in the analysis, right, which is that the evidence has to be discovered because of an illegal seizure. And that's sort of the bare minimum. And then even after that, we ask some additional question, which, we are here to discuss under Davis and Hayes and our decision in Oscar Torres. But I am not clear as to why we're even in that territory here, because it doesn't look to me as though the illegal Fourth Amendment search here, which was the search of the home, was necessary to getting the fingerprints, because it seems as though your client, there was probable cause to arrest your client on state drug charges, even independent of the illegal search of the home, and probable cause to bring him in on the federal unlawful presence charge based on the statements he made during the legal encounter on the street. So I don't know if I'm framing my question right, but it seems to me we don't even have but-for causation here, and that's sort of the bare minimum, and then you get into the question of what else you need.
Well, I think that's actually more a question of inevitable discovery. And the government has the burden of proving inevitable discovery under Nix versus Williams.
Why is that the question? Why is it I don't think it is an inevitable discovery question. I guess I'm asking, why isn't it just the first order question? Did they get this evidence because of the illegal search of the house? And if the answer is he was arrested and could have been arrested based only on the evidence from the legal encounter on the street.
Because I believe the evidence was that they didn't want to arrest him for those charges. And furthermore, with respect to the state charges, the only contraband found before the search of Villa's home was drug paraphernalia, and an arrest for that charge doesn't even result and fingerprinting under the North Carolina statute. So as far as that's concerned, that wouldn't have resulted in fingerprints. They had to get the fingerprints in another way. But the officer testified repeatedly that he wasn't going to arrest him. He wasn't under arrest at the point where they found the vape pen in his pocket, and he had the discussion with him. And in fact, he testified that they arrested him on the state charges as a placeholder so that he could further investigate the federal charges.
So you're saying, I think I understand now about inevitable discovery. You're saying maybe they could have arrested him on those charges, but they didn't, or based on that evidence, but they didn't. So now the burden is on them to show that they would have arrested him based only on the legally obtained evidence. Okay.
Right. So the district court's analysis conflicts with Oscar Torres and impermissibly restricts the exclusionary rule. The correct rule under Oscar Torres is whether officers intend or expect that an arrest will lead to criminal prosecution. And here, no one can reasonably dispute that police were motivated by a criminal investigation and planned prosecution when they arrested Villa and had him fingerprinted. Most importantly, they arrested him on criminal charges.
Counsel,
yes.
Counsel, on that point, I was a little unclear on what you think we said in Oscar Torres. You just said it has to do with whether there are criminal charges or criminal investigation. Can you articulate for me, police cannot take fingerprints if what?
So the rule in Oscar Torres is, so the correct test is whether officers intend or expect that an arrest will lead to criminal prosecution. And really the only reason that Oscar Torres...
The reason I'm asking is because isn't that always the case, right? You're arrested on criminal charges for a criminal prosecution. That seems to always be the case. So I understand your rule must be more nuanced than that, but I'm having trouble understanding what it is.
Well, I actually don't think that it is more nuanced than that, because Oscar Torres only came into existence because of the administrative detention and fingerprinting that took there during an immigration investigation. And the court in Oscar Torres went through a whole analysis of the deterrent value of the exclusionary rule in the two different contexts, and explained exclusion wouldn't deter unlawful arrests intended solely for deportation because the exclusionary rule doesn't even apply in deportation proceedings.
Yeah, I think the context is very important for Oscar Torres. I think you're right. And perhaps I'm being too simplistic, but could you state your rule for me when officers can't take fingerprints when or if what?
Well, they can't take fingerprints if it's the result of an illegal arrest, but that's not the end of the analysis, because the court then will apply the Wong-Sun analysis to determine whether those fingerprints were obtained by exploiting the illegality or instead by some other means that's sufficiently distinguishable to be purged of the primary taint.
And so you haven't argued on appeal that this was an illegal arrest.
No, we are arguing that it is the fruit of the illegal search of his home. That's correct.
Okay.
So, but I think that even under a different test, even under a test that is more narrowly tailored to the intent of officers, that the fingerprints would still be excluded here, because before Villa was even arrested on state or federal charges, the officers here were investigating him for federal charges involving his immigration status, charges that they knew would involve running his fingerprints during the investigation. And that was borne out.
I'm sorry to keep coming back to this, but so you said the rule is that officers can't take fingerprints if it's the result of an illegal arrest. You're not arguing on appeal that this was an illegal arrest. So why is this an issue?
We are arguing that it is an illegal arrest because the arrest was the fruit of the unlawful search, to be clear.
I didn't see anything in your brief saying there wasn't, probable cause to arrest or anything like that.
No, and we don't make that argument because there was probable cause, but it was based on the evidence they discovered during the unlawful search.
but you did say, I think you agreed with me, that there was in fact probable cause independent of the illegally obtained evidence that would have supported an arrest. It's just that that's
they
not
chose
why he in fact
they
was
chose
arrested.
not to use that to arrest him because they didn't want to arrest him for that. They had, they wanted to arrest him for a more serious charge, one that they would have to release him on. They did not want to arrest him for the vape pen. And it's clear that they
Can I ask, and it's possible that I'm going to be overlapping a little bit with Judge Rushing, and I apologize. What I am trying to get a handle on is, let's assume, for purposes of the argument, that there's an illegal arrest here. And so now we're trying to figure out, as you said, when is the taking of the fingerprints sufficiently attenuated from the illegal arrest that got the person into the station house and in a position to have his fingerprints taken. And I would have thought that the answer under Davis and Hayes and Oscar Torres is, if the arrest was for the purpose of getting the prints to tie this person to a specific crime, like you've got a crime, you're trying to figure out who did it, and so you start, as in Davis and Hayes, just kind of rounding people up to see if you can match their prints to that crime. And that seems very different to me from doing something like arresting someone and doing a standard sort of criminal investigative check. Are there outstanding warrants? Does this person use an alias? What can we find in our databases about this person? Is that not right?
I may have lost the thread there, Your Honor.
Fair enough. Like, I realized there wasn't really a question. I guess I'm saying, yeah.
But what I will say is, even with a narrower test, I mean, even if you look at the intent of the officers here in making the arrest, I think that the agent or Detective Stewart was pretty clear on page 335 of the joint appendix that he said he was placed under arrest for the state charges for the marijuana until I could further the investigation on the firearms that were present in the house. So his entire purpose in arresting him on these state charges was to conduct exactly the kind of investigation that happened.
But they didn't need his fingerprints to tie him to the guns.
Well, they needed the fingerprints in order to tie him to a status that would make his possession of the guns illegal. Because without
he told them that he was here illegally.
It's not clear whether Stewart fully understood that until he had the Spanish-speaking INS officer or HSI officer speak to him. I think that is the point in which it was clear that he was here illegally, and not before. And that was all part of the investigation that was intended, that was done while they were using the state charges as a placeholder. I would like to take a moment to move to the vindictive prosecution question, because that also presents some significant issues. The prosecutor's decision to charge Villa with a more serious offense after he prevailed on his suppression motion violated due process, because in this situation, there is a reasonable likelihood of vindictiveness. The Sixth Circuit's decision in the United States versus Ladeau, as well as this court's decisions in Wilson and Corbett, support applying a presumption of vindictiveness. In Ladeau, the Sixth Circuit explained that the prosecutorial stake in a successful dispositive suppression motion is virtually the same as the stake that the Supreme Court identified in Blackledge is sufficient to justify a presumption. Villa's successful motion eviscerated the government's case, and the prosecutor had to dismiss it and begin again from square one. Ladeau isn't distinguishable from this case in any meaningful way. As in Ladeau, the prosecutor had charging options, and he chose to charge the more serious aggravated illegal reentry offense instead of the less serious entry offense.
Well, isn't it distinguishable in the main way that the parties are arguing over, which is the district court's factual finding that the government didn't have a reason to charge the aggravated reentry offense until much later, when it discovered the alias and these other charges and these other convictions, right? So, I mean, that's the big difference with Ladeau, and it all comes down to the district court's fact finding that the parties disagree about.
Well, I think it comes down to actually what legal standard the court wants to apply in determining whether the presumption applies or not. And the question is, does that standard require the prosecutor to have knowledge, Or is it enough that the reentry charge was available all along? And Supreme Court decisions and this court's decisions support applying a standard of availability.
Isn't isn't vindictive prosecution a genuine animus standard? We've said, the Supreme Court have said that, the two prongs, the prosecutor has to act with genuine animus, and the defendant wouldn't have been prosecuted but for that animus. So how can we create a sort of idea that the prosecutor has all the knowledge of the government, which makes a lot of sense in the Brady, producing materials context? Why does that make sense in a context where we're asking, did this prosecutor have genuine animus against this defendant?
Well, I think it makes more sense to apply that question in the rebuttal stage than in the presumption stage, because the Supreme Court's decisions in Godwin, Pierce, Blackledge, and this court's decision in Wilson all focus on the availability of the charges, or the question whether it was impossible to bring the charges in the first instance, which it wasn't in this case.
Can I ask you a question about in the very similar context of vindictive sentencing, if someone wins on appeal and goes back down and gets a higher sentence? I thought the Supreme Court had made pretty clear that there's no presumption or the presumption is rebutted if the district court in resentencing is relying on information that it didn't know about the first time it's sentenced, whether or not the thing itself had happened before or after the original sentencing. In other words, it was what was in the district court's head, not what information might have been available out there in the world. Does that seem like it would transfer over to this context?
I'm not sure that that's the line. I'm not sure that that's the line that's drawn. I know that in Goodwin, it was something that happened as a criminal conviction that happened subsequently. And in another case, it was facts that were developed later, or the fact that the defendant had gone to trial later. But
it ought to be the same rule. We agree. Same analysis we're applying over on the sentencing side ought to apply over here.
I don't think so, because this case is different. Because what happened after Villa prevailed on his suppression motion was that, unfortunately, the prosecutor was exposed as not having investigated his case previously. To put it bluntly, it made him look bad. And nobody likes to have their mistakes exposed to judges or their bosses. And Villa's successful motion exposed that the prosecutor hadn't prepared his case, which provides motivation for a vindictive charging decision. So in that situation, I think it is distinguishable from the situation in which a sentencing judge learns additional information that existed but that he was not aware of previously. So my time has run, and I'll just, in conclusion, ask the court to vacate the judgment, instruct the district court to dismiss the indictment, or alternatively to order the suppression of Villa's fingerprints and the evidence derived from them. Thank you.
Great. You've got some time on rebuttal. Ms. Ray?
May it please the court, Amy Ray for the United States. Your Honors, the district court properly denied both motions to dismiss and the motion to suppress. I want to begin with the vindictive prosecution argument and say that there are two requirements. There has to be a motive, a vindictive motive, and also, but for that vindictive motive, the new charges would not have been filed. Now, what the Supreme Court has held and this court has recognized is a presumption plays a role when the defendant cannot show those two things. But the presumption plays a really important role, which is serves the purpose of allowing the court to find a vindictive motive where the circumstances suggest that that motive was likely. And that means all of the circumstances. Now, contrary to Ms. Hester's argument, this court and the Supreme Court have made clear that a pretrial decision to add charges is usually not vindictive. It actually requires a higher standard, if anything, than a post-conviction claim of vindictive prosecution. The purpose of the presumption is because what lies behind all of it is to make sure that defendants do not feel deterred from exercising their constitutional rights. And so the question becomes, Would a defendant in this defendant's position, would a reasonable defendant feel deterred based on the totality of the circumstances? And what Goodwin says is, it's not just where a prosecutor finds new evidence, but it can also be where a prosecutor has a greater appreciation. Goodwin in the Supreme Court specifically recognized that part of a prosecution decision and process is where a prosecutor may realize later in the prosecution process that the evidence has more significance than she or he realized. Now, we take very serious issue with the suggestion that our prosecutor failed to prepare for trial or wasn't ready for something, or in fact did anything wrong. And the district court found that the prosecutor did nothing wrong in this case. The prosecutor explained.
Counsel, I'm sorry.
Yes.
Can I ask you a question, Ms. Ray, about
Sure.
Goodwin and your argument? So I don't understand you to be arguing, but tell me if I'm wrong, that, you know, as a matter of law, there can be no presumption in the pretrial context, like end of story. I take you to be arguing that, you know, Goodwin suggested, and we have said since then, like, you know, it's pretty, it's rare that you would find that presumption in the pre-trial context. Maybe there shouldn't be one at all, but that you are arguing whatever we don't have to reach that here because clearly on the facts of this case, no presumption. Is that right?
Absolutely, and I'm not saying that it never could occur. I am saying, though, that this court hasn't found it yet, and I am saying that Ladeau is easily distinguishable, and this court has not gone as far as the Sixth Circuit. The Sixth Circuit has recognized and found pretrial presumptions to be appropriate. Now, it is not to say that this court couldn't under certain circumstances. The reason I mentioned Goodwin is because the suggestion that a prosecutor has a duty at the beginning of the case to find every piece of evidence that supports the most serious charge that she could lodge against a defendant, and then doesn't do that, that the suggestion that they have to do that or be susceptible to a claim of vindictive prosecution, a presumption that she was vindictive in prosecuting, just makes no sense whatsoever. And it's not particularly, it is completely divorced from the point of the vindictive prosecution, which is to say, would a defendant feel deterred? Well, the district court found a defendant in these circumstances would not be deterred because the prosecutor didn't know and that he had been convicted of 2 serious felony convictions in Georgia, or that he had been illegally that he had been deported and come back. Now, let's be clear. Part of why the prosecutor did not know is because his case agent ran the criminal history and none of it came up. So even though the pretrial services report existed, which was not conclusive, especially on the deportation issue, the case agent ran the criminal history of Francisco Villa, and neither his prior deportation nor the prior convictions came up. They didn't know about it. And there's no duty for them to know about it. This isn't a Brady situation. This is, when is it reasonable to impute vindictive purpose? And it's not reasonable, and the district court, as an abuse of discretion standard of review, was very reasonable in determining that it wasn't there's no reasonable likelihood of a vindictive purpose under the circumstances of this case. And one other point I would make about Ladeau, in addition to just sort of factually it's distinguishable, it also came up in the inverse procedural context, which is that in Ladeau, the district court applied the presumption. So on appeal, the question was, did the district court abuse its discretion in finding that presumption? Here, it's the opposite. The district court did not find the presumption applied. Is it an abuse of discretion? And the answer is no. Turning to the suppression issue, here's the rule from Oscar Torres. When police use an illegal arrest as an investigatory device in a criminal case for the purpose of obtaining fingerprints without a warrant or probable cause, that's when those fingerprints should be suppressed. So when they use an illegal arrest, we have no illegal arrest here. Whether or not the officers intended to arrest the defendant based on the vape pen that they found in his car, or based on the additional vape pens they found in the house, is immaterial, because they found evidence in the car. It's an objective standard. It matters not what the officers intended to do or why they chose to arrest him or whether or not they intended to based on one or the other, right? It's an objective standard. The objective standard is they had a vape pen from the car that independently supported his arrest. And he was arrested for paraphernalia, and they fingerprinted him for that on the basis of his arrest for those vape pens. So there was no evidence, and detention officer Steele testified that what happens is the magistrate judge brings a copy, brings the charge to the defendant, and on that is checked, fingerprint or no fingerprint. But we had no illegal arrest that triggers that analysis. But if we get to that analysis, the district court did not clearly err in finding that the purpose of this arrest was not to obtain the fingerprints, it was to prosecute him for marijuana possession and possibly for the firearms. But at the end of the day, the fingerprints were not necessary, and they were taken as part of an administrative process. The Speedy Trial Act issue, I think, turns in large part on the same issues that are presented in the vindictive prosecution claim, other than at least the first part of it, which is, what is the date that we go from when we're calculating how long between the indictment and the trial? Do we begin with when he was originally indicted on the firearm charge, or do we begin when he was indicted on the illegal reentry case? I want to address one thing, which is, this was this prosecutor's honest journey from, realizing that his trial was coming up, asking his case agent to get the fingerprints, and then the case agent actually offered, should I go ahead and run those fingerprints? And this was before the suppression order entered. And she said, yeah, so they went ahead and did it. And then shortly after the suppression order was entered, they came back and realized, okay, he's got, he illegally was deported before and he illegally re-entered. So the date starts from the time of the indictment for the illegal re-entry offense. So there's not really a Sixth Amendment analysis, but even if there is, even if we go through the Barker factors, the district court did not clearly err in its assessment of those factors.
Ms. Ray, let me ask you this. Ms. Ray, let me ask you this.
Yes,
under the circumstances, could you have obtained a superseding indictment in this case?
We don't think so, but I'll respond to that with a couple of points. One, at the time that we decided to indict Mr. Villa, we knew that the other charges were going to be dismissed. Now, this is, we were also just in all candor to the court discussing whether to appeal that decision, and there were some pretty intense discussions about that. But we did know that that indictment was going to be, that those charges would be dismissed. It didn't make a lot of sense to try to supersede. But even if we had, I would suggest that no, we couldn't, or at least it would not be advisable to try to supersede based on the illegal reentry charge. The facts that we had to prove, the elements were very, very different. The only similar element was that he was an illegal alien. But also, there's a chance that the defendant would have moved to sever because he probably would not have wanted the evidence of his prior convictions to be presented to the jury that would consider his firearm offense. So we did not think that it was appropriate to supersede. It was considered, but it seemed like the most logical choice when we were faced with the fact that we were going to be dismissing the firearm charge anyway was to indict anew. And I will say there was no concern at that point about speedy trial issues. That was not part of the calculus.
Can I ask whether...
Yes.
Oh, go ahead, Judge Harris.
Go ahead, Judge Rushing. There you go.
On the superseding indictment question, I'm looking at what other circuits have said about this question of when the speedy trial right, when that clock starts running for constitutional purposes, when you have new charges. Does it matter that the charges are brought in a superseding indictment versus in a new indictment and a new case? Or it seemed to me it matters more how similar the conduct is or whether it arises out of the same transaction. I don't know. Courts have different standards for this, and I know the parties didn't really take a position on that, but how relevant is whether it's in a superseding indictment or not to your analysis?
So I would say, Judge Rushing, that I did not find, and the defendant didn't cite a case where it was held that there was a new indictment and that related back to the original, and those cases may exist, but it is important whether or not even in the superseding context, how close they were, and whether or not they are tied to a similar set of facts. And this wasn't. He possessed 8 firearms in his house. That was the primary conduct that we were talking about with the firearm offense, and obviously very different conduct with the illegal reentry offense. So I don't think
like maybe that the conduct question should, I mean, the indictment question is really up to the government, right? I mean, the defendant can move to sever or whatever, but it's up to you guys whether you choose to put it in a superseding indictment or a new one. So should that factor into the rule at all?
I mean, I don't think so, unless there's, perhaps in a context in which it was very clear that we could and should have. I mean, it's hard for me to even imagine that circumstance, because then you're more likely in the vindictive prosecution realm, I would suggest, than in a Speedy Trial Act or Speedy Trial constitutional violation context. Here, we just we didn't think that the facts supported filing a superseding indictment. We did not think that they were close enough under the Joinder rules of Rule 8 and the factors that we would consider. And again, we knew that the indictment was going to be, the charge against him on the firearm charge was going to be dismissed anyway when we made the decision.
And that second point about the Joinder, I mean, it's not strictly the same, but that's, I think, really where the action is, right? Are these, other courts are looking at, is this conduct similar enough? Does it all come out of the same transaction? Are there different elements? Whatever their standards are, they're looking at, whether the clock should relate back to the original indictment based on the similarity between the charges.
Right, because at the end of the day, what's the question? Whether or not the defendant would be prejudiced by it all. I mean, it really comes down to, and a defendant is not prejudiced if you're talking about brand new charges that don't relate back and there's no unfairness. And that's why the Barker test is a balancing test. And two of the most important factors are, did the defendant assert his speedy trial right in a timely manner, and could he show prejudice? And none of those things, the district court didn't clearly err in finding that he didn't show prejudice in this case, certainly not prejudice that's related to the speedy trial concerns, which are trial concerns and not sentencing concerns. And this court held in Lozano, for example, that sentencing concerns generally are too speculative. It was in Lozano, and so the possibility of an appeal is just too speculative to fall within the kind of Sixth Amendment speedy trial concerns that the Sixth Amendment protects. So yes, I think the question. Yes, Judge Harris.
Can I ask you a question about the other end of the clock that I found confusing? In part of your brief, you argue, actually fall back pretty fast to, look, even if we assume for a minute that the first indictment starts the clock, we're only talking about 14 months here. We're talking about the time between the first indictment and I think between the second indictment, 14 months. But why would the clock stop at the second indictment? Why doesn't it stop on the date of the trial, or maybe the day on which the district court rules on the speedy trial motion? I don't understand why it stops when the second indictment is filed. Assuming for a minute, this is just your alternative argument, that it starts with the first indictment or the first arrest.
Yeah, it doesn't. That was my mistake.
Oh,
so,
okay.
And I apologize for that mistake. Yeah, that was
Is
my
that
mistake.
right, though? I was really confused about that, about the amount of delay, because we have cases where we only count the delay, which we don't call the whole period. It's just the period that seemed like inappropriate, I guess, or the period that wasn't the defendant's fault. I really was pretty confused about what is delay and what is not for purposes of the Constitution.
Thank you, Judge Rushing, and clearly I was as well. I guess when I went back to it and sort of looked at it, I thought, after I read Ms. Hester's reply brief, I thought, yeah, okay, there were definitely cases that talk about trial between the indictment and the trial. And so I figured Truthfully, I don't think that 19 months versus 14 months as a constitutional matter really matters very much. And if we look at the cases and what kinds of delays have been held to be constitutionally infirm, 19 months really isn't in the ballpark unless the defendant can show prejudice that the defendant hasn't shown in this case. But I just felt like when I looked at it all that I probably should have erred on the side of acknowledging. So hence my statement today that I think there were cases that say it ends at the trial. So from the indictment to the trial, and of course the Fifth Amendment is from up to the time of indictment, pre-indictment delay.
Right.
Do
we remove? Oh, sorry, Judge Harris, go ahead.
No, you go ahead, Judge Ocean.
Well, I was curious about whether we remove the time that the defendant asked for a delay, and because not only because he asked for it, and he asked for it not just because the magistrate judge had ruled that was not the reason, but he also says he's waiving his speedy trial rights, and he doesn't restrict it to the Speedy Trial Act. He says, I'm waiving my speedy trial rights. So do we take that amount of time out of what it counts as delay, or is that not relevant under how this is counted? I really don't know.
Yeah, I don't know either, but I think that this court could choose to say that he waived it with respect to the constitutional analysis because it wasn't, because he didn't use those words, I'm intentionally waiving my constitutional claim, then I feel like
true.
It also probably, if I were looking at it, would say that does count in terms of the time, but where those continuances come in fairly is, of course, the reasons for the delay once we get to those Barker factors. So I think that he's shown enough to get to the Barker factors if, and it's really important if we start from that first indictment, which I don't think this court can or should. But if we start from the first indictment, then I think he gets to the Barker factors, and those factors the district court reasonably found weigh against a finding of a constitutional violation. If your honors don't have any further questions, we respectfully request that this court affirm the judgment of the district court and hold that this prosecutor did not, there was no insufficient evidence of vindictive prosecution. Thank you.
Thank you. And Ms. Hester, you've got some time. And can I actually start you with a question about the speedy trial clock?
Yes.
I spent way too much time trying to figure out the stop date for the clock. And it seemed to me that we have not been entirely clear about this, but that it's supposed to be either the time of the trial or maybe the time the district court rules on the motion, because at that moment, the district court may not know how much more delay will be involved. But in this case, the district court said specifically in its opinion that, at least as the district court understood it, your challenge was confined to the delay before the second indictment, 14 months, and that you were raising no challenge to the delay between the indictment and the scheduled trial date in January. So the district court thought the only issue in front of it was the 14 months between the arrest and the second indictment. So what do I do with that?
Well, I think the reason for that, of course, is because that's the amount of time that had elapsed at the time that the motion was being considered.
More time had elapsed by the time the motion was being considered, but.
So I'm not sure what to do with that, except to say that I think that the delay that was attributable to the government's failure to investigate, I would agree that all of that delay had occurred by the time they had recharged and the district court had ruled on the second set of motions. By that time, the court was moving the case along. Really the delay was the district court's failure to move on the initial suppression motion for 10 months and the government's failure to investigate their case, which caused them to then bring a new indictment after the first one was dismissed, whereas if they had brought it all together, that second, litigation of that second case wouldn't have been necessary. But I don't have a clear, bright line test for the court, I'm afraid, under those circumstances. I would like to move back to the vindictive prosecution issue. It appears that the government is now arguing that Ladeau should not apply. They did not argue that in their brief. I don't think they should be heard to argue that now. But in any event, they can't cite a case that rejects the Ladeau rule. And this isn't a pre-trial charging decision. The only reason that this did not occur post conclusion of the original case is because the government was had the control over whether that case got dismissed or not. So as Ladeau found, this is the equivalent of a post-trial decision to recharge. It's basically the same type of situation that it would be after a person appeals and requires the government to start over from square one. The effect is the same either way. The government also argues that the prosecutor didn't know, and that should distinguish this case from others in which the presumption of vindictiveness is applied. But again, they don't cite any case where a prosecutor had information and didn't look at it, and that prevented the presumption of vindictiveness from applying. And if the court looks again at those cases that I cited, Goodwin, North Carolina versus Pierce, Blackledge, this court's decision in Wilson, all of those cases talk about impossibility of proceeding on the charges at the outset. And as I explained, the exposure of the prosecutor's failure to prepare his case, which is essentially what the government's arguing, that can't be a reason why, that can't be a valid reason because it is not inconsistent with a vindictive motive. It's quite consistent with a vindictive motive that a prosecutor, just like any other person, having his mistake exposed would have a motivation to be vindictive in response. With respect to the government's argument about abuse of discretion on the vindictive prosecution issue, that really doesn't matter because it's a legal question for this court to decide whether the district court ruled in favor or against the vindictive prosecution issue. It's all legal issues that this court reviews de novo either way. And finally, the government's articulation of the Oscar Torres rule would limit that rule to what Hayes and Davis said. And this court in Oscar Torres expressly stated that it was going beyond the rule that was stated in Hayes and Davis. So the government's articulation of that rule is just not workable.
Hey, counsel, how can we go beyond the rule articulated in Hayes and Davis? I think I'm just misunderstanding what you're saying. I mean, obviously Hayes and Davis, set the rules for us in terms of how to do that attenuation inquiry in this context. How can we go beyond that? What do you mean by that?
Well, actually, they didn't, because what the Supreme Court said in Davis versus Mississippi is fingerprint evidence is no exception to the exclusionary rule. It was just applying it in that particular situation, and it noted other situations that it didn't have occasion to consider, such as whether police could obtain fingerprints on reasonable suspicion or with, something less than probable cause.
Whether they get in the field, that's not implicated here.
No, that's not implicated here. But I think, what the court said in Oscar Torres is that the rule we're articulating is not expressly articulated in Hayes and Davis because it's a different situation. But I think that the court, the Oscar Torres rule is peculiar to the immigration context. I think absent that administrative detention, the court simply applies the Wong-Sun exclusionary rule and asks whether the taint is so attenuated that exclusionary rule doesn't apply. Okay, thank you, Your Honor.
Thank you very much. Thank you both for appearing before us this afternoon and for your assistance. And we are sorry we cannot greet you in person, but we hope that you stay well and that we will see you in Richmond very soon.
Thank you, Judge Harris. Thank you all.
Good afternoon. We will hear argument now in our second case, Progressive Insurance Company versus YE, and Mr. Murphy, we can hear first from you.
Thank you and good afternoon, members of the court. The Article 3 case or controversy requirements are met in this material misrepresentation case, and the district court erred in dismissing the case based upon dicta in the trust guard decision. Progressive had standing to seek rescission based on material misrepresentation, and the case was ripe for adjudication under the Declaratory Judgment Act when the action was filed. And therefore,
Counsel.
Yes.
Sorry to interrupt you so quickly, but speaking of Article 3,
Yes.
I wanted to ask about what's going on in the state court. The last time I checked the docket, it looked like Progressive has filed an answer on behalf of the defendants in state court. So Progressive is participating in the litigation. Is that right?
Yes, Your Honor. They actually they have two reasons to. One was the potential of liability coverage, which would require them to defend Mr. Serrato. Of course, they also had underinsured coverage, which was the first party coverage to the minor. So they have two different interests, which were there when the loss occurred. But to my knowledge, I'm not involved in that action, and I don't have any further knowledge than what you may have from looking at it.
No, that's fine. I was just curious about what was going on because it seems a little bit relevant to the mootness question here. Now that, Progressive, there has been a lawsuit filed, which was not the case when the district court ruled. So there has been a lawsuit. Progressive is participating and has filed an answer and is, defending that. Why is this not a moot appeal now? Because clearly the district court has jurisdiction, one way or the other now.
We had the motions to dismiss on mootness, and the more I looked at it in preparing for today, what really, that development really would be causing an unripe case to become ripe on appeal, really not a mootness issue, because the controversy is still live. Whether the policy is void or valid is very much live.
Right.
So it's almost
the question
like
is whether the appeal becomes moot because the case is now ripe, right? Like we had a case once where a party had not, the district court dismissed the case because the party had not exhausted, and then by the time it got on appeal, the plaintiff had exhausted, and we dismissed as moot because we said, well, now whether the district court was right or wrong, you've solved the problem the district court thought you had, so everything can go on as it should have.
The Fifth Circuit had a case, a zoning type case last year, DM Arbor Court Limited versus City of Houston. And they acknowledged that a case could ripen on appeal, which is what we think here it became super ripe. It was a yellow banana when we filed it. It might be brown now, but it certainly wasn't green when it was filed. But they noted that could lead to vacating the order and remanding for consideration on the merits if the ripeness problem was prudential rather than constitutional. And the district judge here based her decision on both constitutional and discretionary type terms between the standing and the ripeness. So we think that the fact that even the district judge would probably agree with us that the case is ripe now and that there probably is an actual injury, we believe the remedy is to reverse the district judge and remand the case, not to vacate. And the reason is because it's clear that standing and ripeness both existed at the time this was filed. And I can address those.
What difference does that make now, though? If we rule that standing existed at the time, if we rule that, standing existed at the time, so the district court was wrong, that doesn't make any difference than if we rule standing didn't exist at the time, but it does now. Either way, you get to, as long as we vacate in a Munsingware way, either way, you get to proceed with your lawsuit, or they, just as you would have. Yes. And we're just offering our sort of, advisory opinion on whether the district court interpreted trust guard correctly.
I completely agree with you. And just looking at the Fifth Circuit case and other cases is whether that is an option when there was a constitutional concern under the standing, as opposed to just the discretionary that just maybe actually on ripeness, which the filing of the suit seems to address the ripeness, doesn't really seem, in my view, to address the standing, because the underlying claim was based on rescission, not on just declaring language in the policy. So I think from a practical standpoint, either one puts the parties in the same position, that is back in the district court proceeding forward on the merits of the claim. I'm not clear on the case law as to whether or not it requires a reversal or whether simply vacating that order and remanding it not for dismissal without prejudice as the district judge ordered, but for proceeding on to the merits. From a practical standpoint, it wouldn't matter to me at all. I'm just not sure if the case law allows that in light of the basis for the ruling to begin with. Yes, Your Honor.
Mr. Murphy,
I just think one helpful way to think about
what
it. Oh, good. No, you go ahead, Judge Floyd.
Oh, okay. I'm a little bit confused about what you're saying now. I interpret this lawsuit of yours to be one of rescission. It has nothing to do with the duty to defend, except that if there's no policy, you don't have a duty to defend. And I think the district judge misapprehended that. So what is the relief that you seek now? You want to vacate the district judge's opinion, and then what?
What I was just simply alluding to was that I'm vacating the order and remanding it for further proceedings is the same result as reversing it and remanding it for further proceedings. So the court may not have to get into why it was wrong if they believe it's become right.
What's the interplay then with the mootness issue?
Well, I think that the case itself is not moot. It's basically that the basis for her ruling no longer exists. I don't know if that's mootness. It seems to me that she said our case wasn't right because there was no underlying lawsuit. Now there is an underlying lawsuit, so now the case would be ripe. So I see it as a case becoming ripe on appeal issue, not a case becoming moot on appeal. That might be just semantics, but it seems to me that her finding that the case was not ripe, that basis, we think it was ripe anyway. But her finding is clearly, even I think the district court would agree that under her rationale, the case is now ripe.
What would have made the case ripe at the time when you said is that the material misrepresentations were made, the premiums were lower because of that, and then there was a demand letter of $100,000 or so, and so when the district judge confused duty to defend with the voidability issue, it seems to me that the better course would be to vacate the district order and remand the case and to stay away from mootness.
Yes, I don't think the case is moot at all. I think it was ripe at the time. I think that the trust guard language has been very confusing for bench and bar, and so I think a reversal here would help clarify those things. But I think the practical impact of whether the order is vacated or reversed is no different if that basis is there. Yes, Your Honor.
Counsel, so to my ears, like you have said several times at argument, that there is no practical difference in the world if we hold, not that the case is moot, but that this appeal is moot because the controversy coming up from the district court is whether there can be a declaratory judgment action like this before a suit is filed. That controversy no longer exists in the world, right? Because now a suit has been filed. And you've helpfully, I think, clarified several times today that it makes no practical difference. There is no practical effect or distinction between whether we just say the appeal is moot and vacate or whether we address the district court's reasoning and reverse and vacate. And that is the definition of an advisory opinion, right? If it makes no practical difference in the world, we can't do it.
The only caveat I would give you, Your Honor, and I agree with you 100%, and is that when I read the Fifth Circuit case, and this is not something I do every day, there seemed to be a concern that you could not make a constitutional standing issue become ripe on appeal.
Well, you can if the reason the district court says, I can imagine the circumstances the Fifth Circuit is in, and they may be different. I think if the district court says you don't have standing for the exact same reason that the case isn't ripe, you will both have standing and have a ripe case at the moment suit is filed. And then suit is filed, that takes care, that moots out both the controversy about standing and the controversy about ripeness, because they both turn on the exact same thing.
And her order does seem to read that way, but we weren't in front of her. We didn't hear what her thinking was. We got the order. And so I only say what I've just said about the constitutional aspect and standing and an abundance of caution. But I agree. She seemed to base both issues on the same, even though the case law from the Supreme Court and the circuits, they kind of see those issues a little bit differently, but she kind of lumped them together on the absence of a lawsuit pending. I mean, from my standpoint, I agree. It could be advisory because her basis doesn't exist anymore. But the order does, was erroneous in our view. So I don't know if that warrants going forward to address it on, in that way or not. And again, from a practical standpoint, I think this court could fashion, a vacatur that admonish the court to go forward and consider the case on the merits. That's all we're really asking for. The way we get there doesn't really matter to us. And I wouldn't want the court to address things that don't need to be addressed. But we were wanting to make sure that we didn't end up with the case being dismissed, because that could raise other problems for Progressive to get to the merits of the case. And that's why we didn't consent. And it was, again, unclear to us whether the entire order could be vacated or only a portion of it could be vacated. And then we might be back in the same place and have to reestablish standing or argue that again. But I think she did base both her findings of standing and ripeness on the same grounds, and that is that there was no actual lawsuit that had been filed at the time the declaratory judgment was filed. We do think rescission standing alone is a justiciable case. That's been well noted through the years. The Second Circuit was very clear that a claim to rescind is by itself a justiciable controversy, and we think that district court erred in not reading the complaint that way. It obviously, the consequence of the policy being declared void would be that there would be no coverage, as Judge Floyd has pointed out. But the essence of the relief was simply to declare the policy void ab initio, and that was clearly set forth in the complaint. And I think the district court didn't read it that way, but I think that's the only way that's the only ground we were asking for. And I think the standing and ripeness were met. But obviously, if now that the basis that the district court used no longer exists, that's another avenue to remand the case. I'd be glad to address any of the other issues if the court wants to hear about them, but I don't want to waste the court's time on that. I do have some time left that I can come back to.
Great. You do have time on rebuttal. And Mr. Parker, we can hear from you now.
Thank you, Your Honor. May it please the court. I'm going to keep this pretty brief. I probably won't use the whole 20 minutes because I think that the court's already gotten to a point that's very important and that's dispositive of this appeal, which is that this appeal is now moot. I believe Mr. Murphy just said that he believed that any opinion that y'all issued would be advisory, because as things stand today, Progressive is free to refile their DJ action as they see fit, either in state court or federal court, which means that any issue that comes from the court regarding the matter that we hear about today is going to have no effect. And the court can't issue an advisory opinion. And this is the very definition of what an advisory opinion would be. So I think that's a very simple reason to say that this is moot without getting and drilling really far down into the district court's order, which I will admit is a little bit nebulous maybe in trying to discern exactly how her decision was made. But just to really briefly go over that, my reading of the order is that there were two things that the district court did. First, the district court said, you're asking for rescission of the policy. That's your first declaration. And here's an issue with what Progressive wants you to do. That determination wasn't a standing determination. The district court said plaintiff did not properly assert a claim for rescission of the policy. That's not a standing issue. That is a waiver issue. Basically, what the law of South Carolina says is that to properly assert a rescission claim, a plaintiff has to tender the return of the premium payments to the insured prior to being able to seek relief. Now, yesterday, I did a really quick look through some other jurisdictions of what their law on this is. And everything I found said that tendering a return of the premiums is a condition precedent to filing a material misrepresentation claim for an insurance policy. What the district court did was they looked at the evidence before, the district court looked at evidence before it and said, there's been no return of any premiums, therefore you have waived your claim. You have not properly—
Can I just ask you a question? I just have this is not my field at all, so this is just a sort of a, talk to me like I'm a fifth grader, just as a matter of common sense. How could it possibly be the case that you have to give back the money before you bring your claim? What if you lose your claim? Like so you have to give back all the money and then you go to court and say there was a material misrepresentation? What if the court says, no, there wasn't?
Well, what
that
happens—
just seems crazy. Why does that make sense? Because I read the law differently. I thought as a condition of relief, you were going to have to give back the money, but not before the court said, you're right, there's been a material misrepresentation.
And I could see where you're coming from, but my reading of what I read yesterday is that as a waiver issue, that the insurer, after they have accepted money from the insured, once they discover there's been a material misrepresentation, they can't keep that money and then say to the insured, hey, I'm voiding your policy. The steps that are supposed to be taking from the law that I read is that the insurer sends a letter to the insured and says, there have been material misrepresentations, we're voiding the policy, or we're just going to seek to void the policy. And then the insurer has to do one of two things. They either have to tender a return of the premiums or offer to do so. They don't actually have to do it, but they have to do one of those two things. And that's where I think the courts view it as a waiver issue, because what they're saying is you can't, as the insurer, try to void the policy on the insured, but turn around and keep the money they gave. You can't do both things at the same time. If you don't return that money or offer to return it, you're waiving your right to assert a material misrepresentation claim. Now, regardless of whether or not that's correct, that's what the district court's order, the order that's before us today, that's what the district court's order found. Progressive didn't appeal that decision. They didn't raise that issue. It's not in their issues they raised in their brief. They didn't argue it, so it's not preserved for the court's review. And then what does that leave you with? The material misrepresentation claim is gone. So what I think the district court said, well, we're going to construe the pleadings broadly and say you still are asking for basically a determination on your duty to defend and your duty to indemnify. And under pretty basic South Carolina law principles, duty to indemnify, there is no standing until there's been a judgment. So there's no standing, and that's not right. Second, under a duty to defend under South Carolina law, all the cases talk about how a complaint has to be filed. And this is under your traditional case where the duty to defend is going to be based on the allegations of the injured person's complaint. And this is a little bit different because there is a material misrepresentation. But until the lawsuit has been filed, the duty to defend has not been triggered. There's no obligation to defend. And as far as my understanding of, again, majority rules of state jurisdictions, the duty to defend is only triggered by initiating a lawsuit. It's not getting involved in settlement negotiations. That's not considered part of the duty to defend. And the only exception to that is in certain very rare circumstances where there's something like an administrative proceeding that is occurring before the beginning of a lawsuit, and a record's being created there where the insurer is going to want to participate and defend the insured. But that's not the case here. And generally in a personal injury lawsuit, the duty to defend is not going to be triggered until the lawsuit's been filed, because until that point, it's hypothetical and conjectural as to whether or not they're actually going to have to defend. And so, if we go further than that, there are, I think, redressability issues that are implicated by South Carolina's financial responsibility laws. I don't think it's necessary to drill that far down into it, because going back to my first point, I think that anything that the court would seek to do would be advisory at this point, and that Progressive is, yes, Your Honor.
Sorry, I hate to detain us, but I did have a question about your merits argument, which I think is not actually a redressability argument, it's a merits argument. But your understanding of South Carolina law, right, is that it's basically they can't win on a rescission claim because it's too late, because there's already been an accident that harmed a third party. And then your argument on standing is they also can't bring a case before there's been an accident and a lawsuit. So when can you bring a material misrepresentation suit in federal court?
So I thought about this because I anticipated that I was going to get asked this question. And my understanding is, and reading it, and this is what I think, is that a material misrepresentation claim, if you bring it properly, if you don't waive it, if you bring it properly, you don't necessarily have to wait until after the lawsuit is filed, depending on the specific circumstances or facts of the case. But you cannot bring it after the accident has happened. So if the insurer somehow discovers through some type of diligence or information they received that an insurer has lied in applying for a policy, it may be the case that in some instances there is standing to seek a material misrepresentation claim once they get that information and they know that it's happened. Okay. But in this case,
if this is, so you agree that if this is a material misrepresentation claim, you don't have to wait for the accident and the lawsuit.
Well,
your argument is that on the merits, this isn't one. They can't win on the merits on that one.
Yes, Your Honor. I understand that you see it as a merits and not a redressability. I see it as a thing where it's impossible for what Progressive's asking for to be redressed, because what they're asking for is a common law remedy for material misrepresentation, when South Carolina statutory law has abrogated that remedy to the extent they're asking for it after an innocent third party has been injured. But
the redressability question is whether a favorable court judgment would redress the injury. So you have to sort of assume they're going to win on the merits and then figure out, will what they are asking for from the court redress their problem? But either way, I'm just interested in it as a legal question, but you've answered my question about the window for bringing a suit.
Yes, Your Honor. And again, I think that in this case, regardless of whether or not that's true, the district court found that they hadn't properly asserted a claim for rescission, and they haven't appealed that decision. So with that, I would ask the court to affirm the district court's decision. Thank you for the opportunity to be here to speak to you today. Thank you.
Thank you. And Mr. Murphy, you've got time.
Yes, Your Honor. Thank you. And just briefly, the entire rescission claim would not be barred by the automobile insurance statutes that only apply. And one of the arguments is they only apply to certified policies. But even if they apply to all policies, which is one of the disagreements, that would only apply to minimum mandatory coverage, in minimum limits. And in this case, the policy had excess liability coverage, which anything above the minimum limit is certainly subject to common law rescission, equitable rescission, and certainly the underinsured motorist claim of the minor would be subject. I've been in this court on that issue before for Progressive many years ago. So there's no question that there's redressability because this was more than a minimum limits policy and more than just a mandatory coverage claim, which in South Carolina, and I know that's an aside, but certainly there's redressability. And to say that it's been abrogated, if it's been abrogated at all, it's only been abrogated as to the liability minimum coverage of 25, and there's ample coverage above that would be subject to rescission. Also, it's clear in South Carolina law, as an attorney who's brought dozens of material misrepresentations cases, that you do not have to formally tender the return of premium. You certainly don't have to actually make it or pay it if you are seeking a judicial rescission. And in this case, it is, as the court noted, it's a condition of relief. So if the court were to declare that the policy was void, it would only become void upon a return of the premium to the insured, and that can be ordered in the relief. And that's something that we'll deal with on the remand of this case. A unilateral rescission, which some people still do, not just insurance contracts, but all contracts, does require a return of the consideration or the premium before you unilaterally declare the policy void. And that's not what happened here. Progressive went to court and believes that they had an adequate claim to present at that time. So those were just two issues. They're not really addressing the constitutionality, but they were raised. I'm welcome to answer any other questions the court may have, but I think the court obviously is well read on the issue, and I won't waste anyone's time if there are no further questions.
If neither of my colleagues has questions, and I think we are set. Thank you both very much for your time this afternoon. We appreciate it. We're sorry that we can't thank you in person, but we hope that you stay well and that we will see you in Richmond soon.
Thank you, Your Honors. Thank the court.
Thank you.
Oh, and I guess we can adjourn court for the day, please.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Judges, I will move you to the robing room now.